Okay, so for this case, the details and the background surrounding this case is that Kayla Bowie purchased a vehicle from Matar that was priced at $5,500. She put down a deposit of $1,500 and then paid 3 subsequent payments of $100 each, so that's $1,800 of the $5,500 that she owed. She stopped making payments towards the car because the car no longer worked. She purchased the car on May 12th, 2018, and the car is still in her possession, so she still has the vehicle. The plaintiff, Kayla Bowie, is suing because the car no longer works, which she believes is grounds for a refund towards the funds that she's already paid. Now, the written contract that she signed, it states what the property is, what the sale price is, and what the payments are. The contract also states that the car is being sold as is without any warranty of any kind. However, Ms. Bowie, the plaintiff, claims that they had a verbal agreement also that stated that Matar would take care of any problems that arose with the vehicle. So that's why she believes that she is entitled to a refund for the funds that she paid towards the vehicle. Now, the question here is whether or not Ms. Bowie is entitled to reimbursement of the funds that she paid, or whether or not Mr. Matar is entitled to the remainder of the funds that Ms. Bowie has not paid because she has not finished the payments of the $5,500. So Judge Judy, she focused on whether or not a verbal contract can supersede a written contract. And in this case, she stated that verbal agreements do not alter a written and signed contract, which in this case, the written contract stated that there is no warranty on the car and that the car is sold as is. Now, in Somerville versus Gullett Gin Company, a similar claim was made in which the plaintiffs based their argument on a verbal agreement that was not in the written contract. This is also regarding a warranty. And so the court determined here that the verbal warranty cannot be established outside of the written contract. They stated that we do not see furthermore upon what principal parole evidence could be admitted to vary the terms of this written contract and to establish an independent verbal warranty. And that's Somerville versus Gullett Gin Company, and that's 194 Southwestern Reporter 576, if you want to look that up. So then, Tennessee Code Annotated also states that the contracts for sales of good with monetary value of more than $500 is not enforceable unless it is in writing. It specifically states, except as otherwise provided in this section, a contract for sale of goods for the price of $500 or more is not enforceable by way of action or defense unless there is some writing or record sufficient to indicate that a contract for sale has been made between the parties and signed by the party against whom enforcement is sought or by his authorized agent or broker. And that's Tennessee Code Annotated 47-2-201. So Ms. Bowie purchased the vehicle for $5,500, which would require a written contract, therefore making any verbal contract or counteroffer inadmissible. It's not going to be binding. The written contract between the two parties that clearly states the detail of the car shows that there was an offer, acceptance, consideration, intent, contractual capacity, and the subject matter is legal. So the contract is valid, and Ms. Bowie's failure to make the remainder of her payments puts her in breach of the contract because she is not making the payments that she signed and was contracted to. So in GMAC LLC versus Kimbrough, the defendant failed to make contracted payments for his vehicle, and subsequently the vehicle was repossessed. The court held the defendant responsible for paying the remaining $18,000 owed on the car to the facility, and that's GMAC LLC versus Kimbrough. It's not cited in any of the reporters. It is a website. And then the court is going to hold Ms. Bowie to that same standard because she's going to be required to pay the remaining balance on the car since she was in breach of the contract. Therefore, Mr. Matar is going to be entitled to the remainder of the funds. So in conclusion, Ms. Bowie and Mr. Diop entered into a written contract after she purchased a vehicle from him on May 12, 2018. Ms. Bowie was required to pay a total of $5,500 to Mr. Diop, and she only paid 4 payments, equating to $1,800 total. Though Ms. Bowie claims that Mr. Diop breached the verbal contract stating he would repair her vehicle, the verbal contract is non-binding, and she is still held within the confines of the written contract, therefore putting her in breach of the contract for not continuing to make payments. Ms. Bowie will be required to pay Mr. Diop the remaining balance of $3,700.